to the
Good afternoon, Chair.
Recording in
Good
progress.
afternoon, Chair.
afternoon to the delegation from the Department of Employment and Labor, honorable members, staff of the committee, and also staff of Parliament broadly, media, PNG. Welcome everybody. The time is 1600 hours. We had scheduled our meeting for 1600 hours and we are now starting. Can we just get an indication, committee secretaries, in terms of attendance?
Good afternoon, Chair and honorable members and colleagues.
Yeah, what's happening to your face? We can't see.
Hi, Chair.
We can't see
You can't see
properly.
me. Okay.
That's the Parliament.
Chair,
It's like your face is covered with.
I don't know what's wrong with my face, but I've got a load shedding from my side. But what I can say for
maybe
now,
maybe the window is behind you. There's a light behind you, and then it reflects. Okay, you can go ahead and tell us who's in the meeting, and if there are any apologies. You can go ahead. We can't hear you now. We've got this cloud that is next to you as well, that makes you invisible. You are muted. I don't know whether it's difficult to even see whether you're saying something. I see that you are muted.
Chair, can you hear me now?
Yeah, we can hear you now.
Okay. For now, Chair, we have Honorable Mama Rehane, Honorable Maimang, Honorable Boshoff, and yourself. At the moment, we have not. And who?
No, I'm saying okay.
At the moment, we have not received any apologies from the members. We also have Ms. Isaac, Ms. Williams, and Mr. Mjangane sent an apology to say he is still busy with the Intelligence Committee.
But Mr. Moimang is part of the Intelligence Committee.
Maybe he will log in later. I'm not sure, but he said he spoke to you about this.
No. He spoke to me about the report. You remember there was that organization that was making complaints about the Gazette.
Yes.
And then I had asked him to send us a written presentation with regard to his investigation. Then when we made a follow-up, he said that he was busy with the Standing Committee on Intelligence, so the report will not be ready. And then we said, okay, he can send the report in our next meeting, which will be on the 15th, but it didn't mean that he should not attend this meeting. I see Honorable Moimang.
We also have Mr. Apleni.
Oh, okay. I see Mr. Moimang send this up.
Thank you, Chair. I want to believe that this is their full time, which probably might have an impact in terms of what we expected from him, which could be the reason as to why he said he saw that committee. Maybe the other his seniors must talk to him so that at least that work should be given to one of his colleagues to be able to meet our expectation as a committee. But I know that is there full time now. Thank you, Chair.
They're in the intelligence.
Yes, Chair.
Oh, okay.
Chair, we also have the stakeholders that presented their submissions in our last meeting, and we also have the department.
Okay.
Thank you, Chair.
All right. The stakeholders will be here as observers in this meeting, so they won't be allowed to contribute. They had their opportunity last time, and now we'll hear from the department on the employment equity, as well as on the COIDA amendment bill. Welcome, everybody. Can we then start with the employment equity, if the responses? Over to you, Mr. Mkale.
Thank you, Chair. Maybe first, before we continue, we'll just introduce the delegation from the department. We've got Karabo Magangane, we've got Vuyo Mafata, Niresh Singh, Mili Reitas, and Harry Mapokokhela. Now, that's a delegation. If I miss up anybody, who Mr. Mafata can assist. My colleague, Nswaki Mamashela, Honorable Chair, will do the presentation. Nswaki, can you fly the presentation and then do the presentation? We'll take the questioning together, but she will do the presentation. Thank you, Chair.
Thank you, Honorable Chairperson, and good afternoon or good evening to honorable members of the committee, the senior management of the department, my colleagues from the legal service in Parliament, our stakeholders that made presentations to this committee. Chairperson, I'm trying to put it in a slideshow. I think it's clear now, Chairperson. Chairperson, I need to explain upfront that our responses on the Employment Equity Bill actually summarizes responses on both the written submissions and the oral presentations that were done to the committee on the 22nd of Feb. You'll see in the slides, Chairperson and honorable members, that we are actually giving the constitutional mandate and the purpose of the act, and then we dwell into the matters arising from the written and oral submissions by stakeholders, and we'll talk to the issues relating to the issuing of the compliance certificate and areas where we agree with the proposals that were made in the presentations, and then give an update on the consultation process with the relevant sector stakeholders regarding the setting of sector targets. However, Chair, seeing that this is not our first presentation to this committee, we did a presentation outlining the provisions of the amendment bill previously. I will not bore you, Chairperson and honorable members, on the constitutional mandate, which emanates from Section 9 of the Constitution. This is the provision dealing with the protection of human rights to equality and the elimination of unfair discrimination. And we are all aware, Chairperson, that the Employment Equity Act was enacted to give effect to the provisions of Section 9 of the Bill of Rights in the Constitution. And in this regard, Chairperson, the purpose of the Employment Equity Act is to promote equal opportunities and fair treatment in employment by eliminating all forms of unfair discrimination in any employment policy and practice. And also, the second leg is to actually implement the affirmative action provisions to ensure that those that were previously disadvantaged, meaning Black people, which are African, colored, and Indian, women of all races, and persons with disabilities, irrespective of their race and gender, should get a fair opportunity to participate in the economy. Chairperson, I'll then go straight into the matters that were arising from the submissions that were done both written and orally to this committee. We have tried, Chair, to summarize all the matters according to common themes that were emanating from the submissions. The first issue that came out, Chairperson and committee members, was the constitutionality of sector-specific EE targets versus quotas, meaning Section 15.3 of the current Principal Act versus the new proposed amendment, Section 15 capital A versus the framework and Section 217 of the Constitution. The other theme that came out of the submission was Section 16 relating to consultation with employees regarding sector EE targets, and Section 42 on reasonable steps taken by employers versus justifiable reasons in terms of the new insertion in Section 53(6)(b) of the bill. Another area of contention was the issue of Section 53(6) in the E Amendment Bill versus the compliance certificate and the procurement law. Another issue that emanated was the penalties as contained in Schedule 1 of the EEA versus the sector targets. In this regard, Chairperson and honorable members, we gave provision in the slides to recall the current Section 15 of the Principal Act that deals with the implementation of affirmative action. Of importance to the discussions to this committee is Section 15.3 that states that the measures referred to in subsection 2D include preferential treatment and numerical goals, but exclude quotas. This is very important because in most of the matters arising from the submissions that were made by our stakeholders relates to sector targets versus quotas. And another section is Section 15.4 that states that subject to Section 42, nothing in this section requires a designated employer to take a decision concerning an employment policy or practice that will establish an absolute barrier to the prospective or continued employment or advancement of people who are not from designated groups. This is very important because one of the submissions also talks on the sector targets being absolute barriers to the prospective or continued employment of other groups that are not from designated groups. In this regard, we are mentioning the white males and foreign nationals that are not part of the designated groups. In this, to give context to the issue of quotas versus EE targets, Honorable Chairperson and honorable members, it's important that we draw a distinction to make it clear that there is a difference between quotas and sector EE targets. Quotas are mandatory and compulsory outcomes. So there's no here or there. It's a must that you comply with quotas. Again, quotas are rigid and must be achieved at all costs. And penalties instituted for missed outcomes, no consideration of justifiable reasons. Therefore, if there is a quota that is regulated, penalties must be instituted if someone does not comply with a quota. And there is no flexibility. And hence we are saying sector EE targets are different, Chairperson, that these are aspirational goals. They are flexible, but attempts must be made to achieve the goals where reasonably practicable. Again, there is flexibility already built into the draft EE regulations that we published in 2018, where we have provided justifiable reasons which are contained in EEA 15 form that is in the regulation. These justifiable reasons, honorable members, were discussed and agreed at NETLAC with all social partners. We'll then dwell into the first issue regarding quotas versus EE targets, which were raised by the Financial Intermediaries Association of Southern Africa, FIA. Their argument is that the current targets are hard-coded and with the current fines and penalties contained in the EA, they amount to quotas. And therefore, non-compliance will impact the licenses of financial services providers. They even provided a constitutional court ruling between the SAPS and the Solidarity Trade Union, which was issued by the Constitutional Court in 2014, arguing that suitably qualified individuals must be beneficiaries of affirmative action, and measures directed at affirmative action should not be quotas but numerical goals. We disagree with this notion, Chairperson, because if one looks at the sector targets, the way I've explained them above in the previous slide is that the sector targets are not hard-coded, and therefore they are not unconstitutional in relation and in conflict with the Constitutional Court judgment that was issued in the SAPS and the Solidarity case. Reason being that the committee should bear in mind that all social partners at NETLAC discussed the provisions of Section 15A and made sure that there should be flexibility created to allow employers to first regulate their own annual targets towards achievement of the sector target that the minister would have regulated. And by setting their own annual targets, Chairperson, employers are required by Section 16 and 17 to actually consult on the annual EE targets towards the achievement of sector targets that would have been regulated by the minister. Therefore, there is flexibility, and that removes the notion of quotas. In addition, I must emphasize that NETLAC social partners made sure that we also make provision for justifiable reasons to be raised by employers in instances where they fail to achieve the regulated target by the minister, the sector target. Therefore, there is flexibility, and employers know about this, those that participated at NETLAC under organized business. Another issue that was raised regarding quotas versus e-targets was from Business Unity South Africa. They are arguing in their submission that the numerical targets which are set will constitute absolute barrier or quota if the certificate of compliance is withheld for failure to actually achieve the sector targets. And they are quoting that this will be against the current Section 15.3 of the Employment Equity Act. They further argue that if we continue to promulgate the amendment bill as it is, inclusive of Section 15A, this will be in conflict with the provisions of Section 2173 in the Constitution. We argue from our side, Chairperson and honorable members, that we disagree with the arguments by BUSA. BUSA was part of the negotiations at NETLAC, where it was agreed that we should create flexibility to ensure that the sector targets are not an absolute barrier and do not constitute quotas. And again, I want to emphasize the flexibility has already been built in two ways in the regulations, by allowing employers to set their own annual targets towards the regulated sector targets, and also by raising a justifiable reason. And we believe that the e-regulations provide implementation guidelines which constitute a framework in terms of Section 217 of the Constitution. There is nothing unconstitutional in this matter, Chairperson and honorable members. We just wanted to also emphasize how the flexibility has been built in, and I've already alluded to the annual targets that are going to be set by employers themselves in consultation with the employees. Again, these are justifiable reasons that are already catered for in the regulations. We agreed with all social partners, Chairperson and honorable members, that employers can raise any of these justifiable reasonable grounds that are inclusive of insufficient recruitment opportunities, promotion opportunities, insufficient target individuals who are suitably qualified, if there is a court order or the business has been transferred, or there are measures or acquisition of business, and the impact on business economic circumstances. We all know now that unforeseen economic circumstances always arise. In the past 2 years, we were hit by COVID pandemic. No one actually planned for this. And this had a huge impact on employers achieving their own EE targets that are in the EE plans. Therefore, we have already catered for such situations that are unplanned and as a result of pandemic like the COVID-19. We argue, therefore, that sector targets are not quotas. We continue, Chairperson, to respond to the issues on Section 15, capital A of the amendment bill. In this area, again, Busa came back and also argued that the sector targets should be set in consultation with the relevant sector stakeholders, and joint consensus seeking approach must be adopted. And they are also arguing that the Act needs to make provision for instances where agreement cannot be reached between the minister and the relevant sector. First, we agree that where possible, consensus must be reached with sector stakeholders on the setting of sector targets. However, we disagree that the bill must make provision for another process in instances where there is no agreement on the sector targets. We believe that after 24 years of employment equity, we have all noticed and we can all agree that there has not been any significant progress because all the EE targets were self-regulated by employers. Even after consultation or in consultation with their own employees, the pace of transformation has been insignificant. We therefore believe that it is important that the minister is given powers to still regulate sector targets based on the advice of the Commission for Employment Equity. I just want to remind members, honorable members, that the Commission for Employment Equity is consisted of organized business, organized labor, and community constituencies, including government. Therefore, these are people with expertise in this area of employment equity. If there is disagreement, the minister must still take advice from the Commission for Employment Equity and regulate the sector targets. The second issue was raised by CASA on Section 15A, Chairperson. They are arguing that there is insufficient empirical evidence to enable the setting of targets. And they commit to collaborate with the department to conduct research, to collect empirical data so that the targets are informed. We disagree with this notion because on an annual basis, employers from the construction sector, they submit EE reports. In these EE reports, there is quality data that provides indication where the sector is in relation to transformation. We therefore don't see any need for another research because the empirical data is already available in the Department of Labor, and the Commission for Employment Equity on an annual basis together with the minister publish the employment equity status of the labor market, reflecting on each of the economic sectors that we are busy consulting. We are continuing, Chair. There were a lot of comments on Section 15, capital A. The Master Builders South Africa also raised an issue here on Section 15, capital A, that the provision is very silent on the criteria for identifying and setting sectoral numerical targets. They secondly argue that the bill is silent on the need for the minister to reach consensus with the relevant sectors. They further argue that Section 15, capital A2, should include a requirement for the minister to determine a criteria for identifying and setting sectoral numerical targets jointly with the economic sectors. First, we disagree that Section 15, capital A, is not clear in terms of the criteria to be used by the minister to identify the economic sectors and for the setting of sectoral targets. If we look at the current Section 15A, capital 15 capital A in the bill, it is very clear that the minister, in identifying the economic sectors, must consult the Standard Industrial Classification of Economic Activities Code, which is published by State South Africa. And this was done by the minister on the advice of the Commission for Employment Equity, and 18 economic sectors were identified and published for public comments in the draft EE regulations of 2018. This was also discussed at length at NETLAC with all social partners, and we all agreed that the 18 economic sectors meet the criteria as outlined in the current bill. And there were no opposing public comments against the 18 economic sectors that were identified and are published in the EE regulations of 2018. On the second issue, we are saying that we agree that where possible, we should reach consensus with the sector stakeholders before the minister can set any sector targets. However, we believe that where there are no consensus with stakeholders, the minister must still have powers based on the advice of the Commission for Employment Equity to go ahead and regulate. If we don't do that, honorable members, then it defeats the purpose of why we are amending the Principal Act. We all know self-regulation has not worked over the 24 years of the Employment Equity Act. Hence, the minister must have powers to regulate the sectors to ensure that we fast-track the pace of transformation. The other issue that was raised, Chairperson, was on Section 15, capital 3 by the Banking Association of South Africa. They argue that this provision gives the minister the powers to set targets in consultation with the National Minimum Wage Commission. And I think they were mistaken because we disagree. They were looking at the wrong version of the amendment bill. This was corrected by the Portfolio Committee on Employment and Labor to revert back to the NETLAC agreement. So if we look at the current bill, Section 15, capital A3 has been corrected, and it refers to the Commission for Employment Equity, and it also says the minister must consult with the relevant sector stakeholders. Here, Chairperson, if you allow me, I'll spend a little bit of time because there were proposals that were given by FIA, ASISA, and SAIA on Section 15A, capital 2. They are requesting that we should delete after consulting, and we should insert all those areas that are highlighted in red, which states that in consultation with the relevant sectors, including regulators where applicable. We disagree, Chairperson. We believe that if you delete the words after consultation, then when we insert in consultation, it means that we are taking away the minister's powers to still regulate the sector targets. And this, again, I want to emphasize, it actually defeats the intended objective of the sector targets, and also it defeats why we want to address the mischief of employers' self-regulated targets. I think over 24 years, we can all agree self-regulation has failed to transform the labor market. The other area was 15 capital A3. The letters that are in red, these are the new insertions that were proposed by the three organizations. They're saying that at the end, where a sector provides sufficient reasons for such a distinction, such a difference in skills requirements, the minister may set different numerical targets per subsector or region. We disagree with the proposed amendments on Section 15 capital A3 to cater for skills requirements because employers had over 24 years of the Skills Development Act to develop the skill set required in their own sectors and by their own companies so that they can transform their own workplaces. We believe that if we have all started in 1998 when the Employment Equity Act and the Skills Development Act came into effect and started building or developing and training people in the required skills, we wouldn't be sitting with challenges where now business is raising the skills shortage as a matter of concern, and they want that to be included in the bill. We believe that it is the responsibility of everyone in the labor market, meaning employers, together with the workers, to identify the skills required for their own sectors and actually utilize the skills levy that they are paying on an annual basis to develop and train people in the required skills. Therefore, the insertion cannot be accepted. The last area was the section 15A, capital 4. At the end, the three organizations are proposing that we delete 30 days and replace it with 90 days to comment and engage with the minister thereon. We disagree with the proposed 90 days for the publication of the notice of the regulated sector targets. The reason being that if we look at the current bill, the 30 days, the bill says at least 30 days, meaning that the 30 days is a minimum time frame required and not a maximum period for the publication of a notice. And we don't understand, there's no rationale, honorable members, that we want the minister to publish the notice on the sector targets for 90 days or more. Because if we say 90 days, it means the minister cannot publish it for less than 90 days. And the act is very clear. The minister cannot publish it for less than 30 days. It can be more than 30 days. The minister can decide that this is a very sensitive issue. The notice will be published not for 30 days, but 60 days or 90 days. But moving it up to 90 days is very unreasonable. And we don't see a rationale also, Chairperson, to actually engage with the minister after the notice has been published, because we would have completed the sector stakeholder consultation before the minister publishes the notice. Again, BASA Chair raises an issue lastly on section 15A that they are of the view that targets that are being regulated should be set nationally and not be differentiated by region, because they believe that most of the banks have a national footprint and they will not be able to comply with multiple sets of targets. And this will result in businesses having the burden of restructuring and having to manage and monitor the compliance requirements. We agree with BASA on this one, Chairperson, that where possible, employers that have a national footprint must be given a choice to comply with national sector targets. And those that are regionally based, they should actually be given an opportunity to choose the regional sector targets. And this can be addressed if the committee could give consideration to the proposal by COSATU to section 42A of the Principal Act, where we can change the word "and" to "or" and allow employers to choose the national economic active population demographics or the regional economically active demographics when they deal with compliance to their relevant sector targets. And we have actually outlined the proposal that was made by COSATU in slide 19, which I'm still going to discuss later on. We are moving now to section 16. I'm trying to summarize, Chairperson and honorable members. Without reading word by word, I believe that honorable members have read the presentation. BUSA is arguing here that if the minister sets sector targets and these sector targets are prescribed for compliance by designated employers in their equity plans, it will override the powers of employers to consult with employees in terms of sections 16 read with section 17 of the Principal Act. And by so doing, they argue that it will be useless for employers to pursue and comply with section 16 and 17 because now the minister would have regulated the targets for them. We disagree with this and with the arguments advanced by Busa, because already, Chairperson and honorable members, the regulations have created the flexibility that if the minister is going to regulate a 3-year or a 5-year sector targets, employers together with their employees will still have powers to consult and regulate how their annual EE targets contained in their own EE plans towards reaching the sector targets should look like. Therefore, there's no conflict between the current proposal of section 15A, section 15 capital A in the bill vis-a-vis section 16 of the Principal Act that deals with consultation, because employers will still have to consult on the annual targets towards reaching the 5-year regulated sector target by the minister. In fact, it is important to highlight that the implementation plans of the amendments is that the minister will not set any sector target that is less than 3 years and nothing more than 5 years. Hence the flexibility that consultation must still take place at the workplace on how employers and their employees reaches the 5-year sector target. We are looking now at section 22 capital A, which is a new insertion in the bill vis-a-vis section 42(1) small letter A, capital A of the E Amendment Bill. First, I'll speak to the section 20 capital 2 capital A that wants to align the numerical goals in the employer's E-plan with the relevant sector targets set in terms of section 15A. The proposal here from the 3 organizations, which is FIA, ASISA, and SAYA, is that we should scrap or delete the word sectoral so that the new insertion talks to the numerical goals set by an employer in terms of subsection 2 must comply with any target in terms of section 15 capital A that applies to that employee. We disagree with the proposed deletion of the word sectoral because employers are required to comply with the sector targets, which are relevant to their sectors. Meaning that if the minister regulates a 5-year sector target, the 5-year sector target becomes a numerical goal that must be reached by each employer in that particular sector at the end of the 5-year period. Therefore, to remove the word sectoral, it actually defeats the purpose of linking section 15 capital A with the requirement to prepare and implement an EE plan towards the achievement of the sector target that the minister would have regulated. We disagree with this amendment. The other one was given by the 4 organizations, the 3 above and Busa, where they are arguing that section 42(1) small letter A, capital A, should state that whether or not the employer has or taken reasonable steps to comply with or achieve the applicable target as set out in terms of section 15A applicable to that employee. Honorable members, we have all looked at the bill and we disagree that the proposal is actually relevant at section 42(1) capital small capital A, small a and capital A, because section 53(6) already prescribes the justifiable reasons or reasonable grounds that any employer can raise for failure to achieve the sector targets, or even to achieve their own annual self-regulated target. And all the justifiable reasons I've already alluded and presented in prior slides. And again, Network social partners agreed, not only in the discussions on this amendment bill, they agreed that the words reasonable steps should be deleted from the principal act, which is section 42. Hence, if you look at the Employment Equity Amendment Act of 2013, section 42 was amended to remove reasonable steps taken by employers, because it's difficult to measure reasonable steps. And this will open a floodgate for abuse by employers in each sector. Chair, I turn back to the proposal that was given by COSATU in terms of section 42A of the E-Amendment Bill. I must say upfront, Chairperson, that the department realized after the bill went to Parliament that the amendment to this section, which formed part of the network agreement, fell off between the department and the tabling of the bill in Parliament. And we believe that COSATU's submission that we live in a diverse South Africa, we are a diverse nation, and often our diversity is linked to the geography. Therefore, it is important that the targets that are regulated should take into account the regional and sub-regional demographic diversity of our nation in South Africa. They argue that the one-size-fits-all targets will not work, will actually create a social strife if we go that route. And we agree to this proposal, Chairperson, and if the committee can consider this proposal to give effect to the network agreement, that we insert the amendment on section 42A of the capital principle to ensure that there is a choice between the national and the regional economically active population demographics. We are just changing the word and inserting or, so that we also cater not only for COSATU's concerns raised in their presentation here, but this will also cater for organizations that operate nationally, just like the Banking Association of South Africa argued in their submission. And Chair, we submit that we think this will be a progressive amendment to ensure that we take into account the diversity in our nation and make sure that those that operate regionally are able also to comply with the sector targets, because they source their workforce from the regional demographic of the economically active population. The other issue was section 53.6, Chairperson. I'm about to finish. It's just that we received a number of submissions to this bill, and we tried to cover all areas in our responses. Section 53.6A, Chairperson, FIA, ASISA, and SAYA made a recommendation that we should insert the reasonable steps as argued under section 42, which I discussed earlier. And with the same notion, Chairperson, we disagree, because if you start defining or prescribing what reasonable steps constitute, we are then going to risk opening a flood of gate for non-compliance, where each sector will come up with their own list of the reasonable steps that must be considered for failure to comply with the sector targets. And we believe that this will actually defeat the objectives of these amendments. Again, there was a submission on section 53.6B, where the three organizations argue that the bill must set out factors that are to be considered in determining whether an entity has a reasonable ground which justifies non-compliance. And these factors should be included in the bill itself. And we argue strongly that the justifiable, reasonable grounds that are contained in the regulations of 2018 should be lifted and be inserted in the Act itself, in this bill. Reason being that it was agreed at NETLAC with social partners that in future there may be other justifiable reasons that needs to be included in the list that is contained under Regulation 16 in the EE regulations of 2018. And if you put it in the Act, it takes a lengthy process to actually amend the Act to include any future developments in relation to justifiable reasons. Hence, it was agreed with all NETLAC social partners that it's important that we create flexibility in the regulation, because the regulations are discussed at NETLAC and we can amend them at any time when a need arises, instead of amending the Act. Hence, we're saying that there were no opposing public comments in this regard, that we should leave the justifiable reasons in the regulations and not in the Act. On those bases, we disagree with this amendment. Again, MBSA had an addition. They also argued in a similar fashion that the reasonable grounds should be in the Act. And they also argued that under the reasonable ground or the justifiable grounds, we should include the minimum period required to complete an occupational qualification. We disagree with these proposals. We believe that justifiable grounds agreed that NETLAC should stand as they are in the current draft regulation to cater for future development. Secondly, we disagree that we should include the minimum period to complete a qualification for each of the sectors. This will be cumbersome because the occupational qualification requirements or the skill sets required by each of the economic sectors, we are talking here 18 economic sectors, it will be a lengthy exercise and cumbersome, and it will allow employers to get away with non-compliance without being punished, because they will move. We believe the skills requirements needs to be based on the needs of the business on a regular basis. So skills audits are done regularly, in most cases annually, to make sure that we match up with the challenges of the economy to sustain the businesses. So it will be a moving post. We will never be able to actually punish or enforce compliance with the requirements of the Act or the sector targets if we consider this request. Again, here also similarly, on section 53.6b, BUSA argues that if we include the two criteria under section 53.6b, which deals with the CCMA arbitration awards for unfair discrimination cases against the employer and the failure to pay the national minimum wage, is not appropriate for this section. They believe that there are different forums that deal with non-compliance in relation to unfair discrimination cases, which is the CCMA and the Labor Code. And they also argue that the LRA and the National Minimum Wage Act provides remedies if employers are not paying the required national minimum wage. We are actually perturbed by the fact that after discussion and agreement at NETLAC, where BUSA was part of organized business when the bill was negotiated, they agreed to the criteria that inserted under section 53.6b. And there is evidence in the NETLAC report, if we look at page 4, paragraph 3.10.1, where there was no social partner that raised the concern to include the failure to pay the minimum wage and also the unfair discrimination award against the employer who has discriminated against employees to be inserted under 53.53(6)(b) provision in this bill. We believe that the network agreement must stand, and this amendment in the current bill must be considered by the committee. There was a new issue that was raised on the fines and penalties, which is not part of the current EE amendment bill. FIA, ASISA, and SAYA, all three organizations argue that the current penalties or fines that are contained in Schedule 1 of the EE Amendment Act of 2013 are not appropriate or should not be applied to non-compliance with sector targets set in terms of Section 15(a). We argue and disagree that this proposal should not stand because we strongly believe, Chairperson and honorable members, that any kind of non-compliance to any provision of the Employment Equity Act, including the setting of the sector targets that will be regulated by the minister, the penalties in Schedule 1 should stand, and the same sanction in the same manner should be levied by the labor courts if an employer fails to comply with the sector targets and has failed to raise any justifiable reason why they failed to meet the sector target or to meet their own annual EE targets towards achieving the sector target that the minister would have regulated. And at NETLAG, I want to emphasize the issue of fines and penalties was never a matter of concern, Chairperson and honorable members, meaning that there was no issue or any concern regarding the existing fines. And we believe that Schedule 1 in the EE Amendment Act of 2013 must stand and be applied as a sanction for non-compliance to sector targets. Section 53, Chair, versus procurement. There was an issue here that if we issue a certificate of compliance, it's a burden in relation to access to state contracts, and also it conflicts with existing procurement provisions. And we believe that the EE certificate of compliance will add impetus to transform the labor market. Just like when an organization bids for a state tender, they are required to submit a SARS certificate, a BBBE certificate. And all that we are saying here as the department is that we should add the EE compliance certificate to the requirements for access to state contracts to ensure that we transform the economy and we do not perpetuate financial benefits to organizations that resist transformation of the labor market. And the rationale why Section 53 was not promulgated, honorable members, in 1998 when the Employment Equity Act came into effect was that everybody assumed at that time in 1998 that employers needed time to develop and implement systems and processes to comply with the requirements of the Act. And we are arguing now that it has been 24 years since the inception of the Employment Equity Act. Self-regulation has not worked. The state contracts are being given to organizations that resist transformation. And now that we have developed tools and the criteria to assess compliance and issue certificates, we believe that we are collecting quality data, and 99.9% of all the reports that are submitted annually are done online. And we think that in the same vein, the certificate of compliance will be issued online. The process will be automated. Hence, we are ready to actually promulgate Section 53. And this is just for information for the Honorable Committee to look how at the process of issuing of compliance certificate. It's going to be automated. There will be no manual certificates that are going to be issued by any of our labor inspectors, so that we avoid any bribery or fraud in issuing of certificates of compliance. There will be verification with the CCMS case management system and the national minimum wage exemption system to ensure that we are giving certificate of compliance to people that meet the criteria under Section 53. And again, small employers will register online, do a declaration in terms of the EA 15 form that is in the regulation, and the certificate will be issued to them immediately if they are paying the national minimum wage and they have no adverse arbitration awards against them for unfair discrimination. This is a simple criteria, and the automation will make it easier for the issuing of the certificate of compliance. SAFSEC argued in their submission, Chairperson, that the labor inspectors will take bribery and there will be fraud in exchange of certificate of compliance. We believe that we live in an environment, Chairperson and honorable members, wherein corruption, bribery is rife. But this should not stop us to enforce the law or have fear to enforce compliance with the law. We must all deal with the two parties that are involved in corruption. We believe that there is a corrupter and the receiver of bribery, and both must be punished to be able to eliminate the scourge of corruption. And we should not deter or be scared to actually continue to enforce all the laws, whether it's labor laws or criminal laws, so that we are able to create peace and stability in our labor market and create society which is free from corruption and bribery. There was an issue also raised by Black Business Council in the built environment. I'm about to conclude now, Chairperson. They want to forge partnership with the department to increase capacity for enforcement. And they were proposing that the act must be amended to allow partnership. We believe as a department that there's no need to amend the law because we are not adverse to partnerships. We believe that any organization, including the Black Business Council, if they want to help the department to enforce compliance, we are welcome to look at their proposal as long as we can improve compliance with the EEA and transform the labor market and create inclusive economies where everyone will be able to benefit from the fruit of our economy. Area of agreement is only one, Chairperson. I'm concluding. We agree with the proposal by COSATU, and we request the committee to consider the inclusion of this amendment on Section 42A, which was part of the initial NETLEC agreement, but was omitted by mistake when the bill was tabled in Parliament. Update, Chairperson, we are continuing with consultations with the relevant sector stakeholders. We started in June 2019, and this far, the financial and insurance sector have reached consensus with the department on the proposed sector targets for the financial and insurance sector. And we are now busy, Chairperson and honorable members, looking at all the submissions in relation to the proposals on sector targets that were tabled by the department and the Commission for Employment Equity. And tomorrow we are also continuing with feedback. We are consulting with the mining sector and will be meeting other sectors that are remaining to ensure that we are ready to implement the amendments when Parliament and this committee have finalized the amendment bill. I thank you, Honorable Chairperson, for the opportunity. We have covered all areas. Thank you very much.
Thank you so much, Mrs. Mamashel. for the presentation on the responses of the department to the submissions that were made by the stakeholders. Before I allow members to ask questions for clarity, I just want to also acknowledge the presence of the Office of the Chief State Law Advisor and also the Parliamentary Legal Unit. Can I give to the Legal Unit of Parliament and also the Office of the State Law Advisors, if at this stage they want to make any comments?
Thank you, Chair. From the Office of the Chief State Law Advisor,
Maybe you got two gadgets there.
Thank you, Chair. Can you hear me better now?
Yes.
Good afternoon, members. Chair, at this stage, we have nothing further to add to the submissions made on the Employment Equity Bill. Thank you.
Thank you so much. Parliament, Legal Unit.
Thank you, Chairperson. I don't want to repeat what the department has said. Maybe just to emphasize the issue. The biggest issue was that of procurement and compliance with Section 217 of the Constitution. And what is required is that where there are employment equity targets, they must be, they're not in any way impeding Section 217. This is about employment equity, and the procurement laws still continue as is. This is an additional requirement of a certificate. So it does not change the existing Preferential Procurement Act or the Section 217 of the Constitution, but it is a pre-requirement of having a employment equity certificate that will be issued by the Minister. Chairperson, Section Clause 4, which was the intended section of 15A, there was a lot of issues about the Minister consulting with the relevant sectors. And the issue was whether the Minister should be in consultation or after consultation. And just like to emphasize the legal difference between in consultation. In consultation, there must be a meeting of the minds. And after consultation, the Minister will be required to give all relevant sectors a reasonable opportunity to be heard and apply his mind to what he's been said. And at the end of the day, he will be required to make the decision. The concern with having in consultation is that there may be deadlock and it will be difficult for there to be a consensus, and there will have to be a deadlock breaking mechanism. Additionally, the Minister is the one that has to account to Parliament, and therefore giving him the final prerogative as to determine this, and he will be held accountable for that, would be preferable in this instance, as it will be difficult where there is an issue of lack of Chairperson, the other issue was about the reasonable grounds in Section 53, where a party has not met the employment equity targets. It could provide reasonable grounds. And just to add, I would suggest that in Section 53.6, it may be 53.6b, it refers to Section 42.4, and it may be suggested that because the department is referring to regulations in which specific grounds will be provided as to where a party can say they have not met the employment equity targets, it may be necessary to tie that up and say that where there's reasonable grounds to justify a failure to comply, it is prescribed in regulations. So just that we can tie up what the department is saying that we are doing with the regulations and Section 53B. Chairperson, there was just some drafting issues that I would refer to in Section 15A, that is Clause 4. There was an issue where one of the public submissions said that the word sectoral should be removed from Clause 6, which is an amendment to Section 22A. So if we look at Section 15A, we see that the heading is sectoral numerical targets. And if we look at the wording in section 15A, it refers to numerical targets in subclause 2, subclause 3. And if we look at clause 6, it refers to sectoral targets. So I did discuss this issue with the Department of Nkalipi about the inconsistent wording. And if the committee so wish, maybe I could discuss this further so we can make sure that there is consistency in the wording in section clause 4 and clause 6. Chairperson, yeah, those were the drafting issues. And with regard to the suggestion about amending section 42A, I think the committee has previously discussed this issue, and we had advised the committee that if it wishes to insert a provision that is not already in the bill, then it will have to undertake a public consultation, as this issue was not put to the public. Chairperson, those are just my brief comments for now. Thank you.
Okay. Now, thank you very much for the advice. Honorable members, any questions of clarities? I think for now we will focus on the questions of clarities, and then next week we'll have a discussion on both the inputs or submissions vis-a-vis the responses of the department, and also do clause by clause voting. And I discussed with the committee secretary that we won't be able to consider the report next week because we will still be considering the submissions and the responses and the clause by clause. But then on the 22nd of March, we will then consider the report. For now, we will focus on the questions for clarities. And if we're done with that, then we'll go to COIDA amendment bill.
Chairperson, let me apologize. I've been trying to log in on 3 devices, but with load shedding, it's been a bit of a challenge.
Okay. So do you have a question? Honorable Dam?
No, Chairperson, no.
Not now, okay. Honorable Boshoff, Honorable Moima, that order, please.
Thank you very much, Chair. Just a question for clarity purposes. The parliamentary legal lady spoke about the insertion of a clause, and if we do go ahead with it, we have to enter into PPPs, public participation. Can she just refer me to the clause again? Thank you.
I think it's section 42A. Remember when the department last time they indicated to us that there was a mistake, they had a consensus around that particular section, but then there was a mistake that it was not included then in the amendment bill. We requested advice both from the legal unit of Parliament and the procedural office. There were conflicting views on the issue. And then the committee then resolved that we will focus on the bill that is before us. But what has transpired since then is that because we advertised the bill, now stakeholders on their own are making proposed amendments, which also include the section that was not part of the bill. I hope, Ms. Isaac, maybe you can elaborate further.
No, I was just making sure whether it's that one, Chair. Thank you. No, okay. I was just, okay, thank you.
Thank you so much.
Yes, Chairperson, you captured the events correctly.
Okay, maybe you can clarify that aspect. Okay, we didn't want to consider it as a committee, but what is the situation when it comes now from the stakeholders? Should we ignore it on the basis that we have a position on the issue already. So can you clarify for us?
Chairperson, in my view, nothing stops the committee from considering it. But if we remember, there's a constitutional court case of the South African Veterinary Association where the committee considered an amendment during its deliberations. And because it didn't go back to the stakeholders and consult with them, then that amendment was ruled unconstitutional. So the committee may consider it, but it must also ensure that the public is informed that this is a proposed amendment, because it was not advertised at the NA stage, it was not advertised at the NCOP stage, and this will be the first that the broader public would be aware of it. So there must be at least some form of consultation before the committee considers and finalize the proposed amendments. So yeah, so you cannot just deliberate on it without a further process.
Okay. Maybe we will have a further discussion then when we deliberate as to what should be the way forward, whether we should stick to our previous position or we consider it and then take the suggestion that you're making of consulting the public about it. Honorable Moima.
Thank you, Chair. Just two areas from my side. The department, in its response to issues that are raised by those that are against the bill, is mainly centered from my own analysis around the assertion that, or the affirmation that the issues that are raised by business stakeholders are issues that were canvassed at NETLAC, and at NETLAC there was consensus. What I want to get a sense from the presenter is from her point, can we did the department engage with NETLAC to give them just at least something in writing to indicate that these are the issues that we have agreed upon? The reason why I'm posing that question, Chase, is whether at some point there might be a need to engage here with NETLAC, because I think that is the thrust of the affirmation that the department is saying, that it's sort of a double standard on the part of BUSA and other stakeholders to having agreed upon NETLAC to come at this level again to raise issues that they had agreed upon at NETLAC. That is the first point. The second one relates to the work of the Employment Equity Commission. In response to suggestion that there might be a need to have a scientific or a research on the progress that we have made in terms of meeting our employment equity targets. The argument is that already we have enough evidence in terms of the employment equity reports submitted by various sectors in terms of their employment equity plans, which is a basis for the consolidation that the work of the employment equity plan is doing. Has there been any engagement with the Employment Equity Commission just to sort of lay this point to rest? Thank you, Chair.
Thank you so much, Honorable Member. I don't know if there are any other members who would like to ask questions. Just on the issue of NETLAC, even if stakeholders were to agree on everything, it doesn't bind Parliament. Whatever consensus they reach, Parliament is free to consider the legislation and take into account the submissions by stakeholders, including stakeholders that also are members of the NETLAC. If they have reconsidered their position and they also perhaps they did not agree with some of the issues, they are free to come back to Parliament and raise the issues. Though it is a dialogue a platform to try and reach consensus, but members of NETLAC individually are free to make submissions that may be contrary to the decisions that have been taken. They've got that right, but that's why also NETLAC doesn't send us a report and say, this is what has been agreed, and therefore consider what has been agreed. It's left to the department to come up then with a bill that could take into account the issues that have been agreed at NETLAC level. But that doesn't bind committees of Parliament and Parliament to agree to what NETLAC has reached in terms of the consensus. I just wanted to maybe
can I make a follow-up on that, Chair?
Okay.
On that point that we have just responded to. I think the key to me is my appreciation of the fact that this bill is centered around key areas which are informed by the progress that we have made in terms of transformation in the employment sector following 23 years of the existence of the current act that we are seeking to amend, which to me it's an affirmation that definitely where these stakeholders are sitting, there is an appreciation that the targets that were set 23 years ago to a larger degree has not been met, and therefore there is a need for urgent intervention on the part of the state. There is a need for the state to ensure that it becomes much more firmer as a developmental state to be able to intervene to expedite the process of transformation in these key sectors. And therefore it becomes important to get a sense from NETLAC and just an appreciation as to is there consensus around that. I think the second point that I saw from the Act is centered around the plans, which to me is also of critical importance. I think section 1 that speaks to employers with less than 50 employees and employers with more than 50 employees, which to a larger degree there is a distinction, and to me it becomes critical to get a sense as to whether at that level issues that are raised in section 1 around the distinction, the importance of it. I know that COSATU on this aspect is quite categorical to say even those employers that have less than 50 employees, this act must apply, which is quite critical because at a small and medium enterprise level, that's where sometimes you'll find the brutal perpetuation of the status quo. But beyond that, also the issue of inspection as raised, the argument labor inspectors are vulnerable to or probe to corruption. Clearly, is an area that definitely you need to get a sense from this body. What is the appreciation of these stakeholders that are coming to make a presentation here, whereas they agreed at that level to say that there is a need to fast-track transformation in the employment sector. Thank you, Chair.
Thank you so much, sir. Okay. Any other comments? Maybe we should just say, Mrs. Mamasha, because there was a lot of debate around the issue of 15A and capital letter, the issue of determination of sectoral numerical targets. For the benefit of members, so that they are also able to articulate. I know you have you indicated what quotas mean and also what targets mean. If you can again maybe try and explain so that members can be able to differentiate. If I may make an example, say about a rugby team, let me make an example about Springbok, where at some stage there were quotas for Springboks. I think at a later stage they did away with that. If they were to come with targets instead of quotas, just can you explain for me numerical targets? What would be the difference? Because I think that's where the stakeholders like BUSA were giving an impression that there is no difference between quotas and numerical targets. And the second point is to how then would there's EE targets at a sectoral level align with the sector, I mean the targets that are set by the employers at a workplace level in consultation with the workers or trade unions. So how would these be aligned? If these targets at a workplace level that are developed for the workplace are not in line with the annual target, what will be the situation in that regard? The last point is with regard to the issue of that section 53, because we also had a long debate in terms of clarification and also the submissions by the stakeholders, particularly 53 D and E. This issue of a double punishment. I saw that you responding to that. You put up the point of the stakeholders on that issue of double punishment. But the question would be, can you use another legislation to ensure the implementation of another legislation? For example, here we're talking about the employment equity bill for now, which will be then be an amendment act if it's passed. So now its implementation is linked to honoring another legislation, implementing another legislation, which is the National Minimum Wage Act. Why shouldn't the National Minimum Wage Act, if there are challenges with regard to it in terms of its implementation, there are no mechanism to address? Why should it rely on employment equity for it to be implemented? If you can just respond to those few questions. But then the last point to Ms. Isaac, that maybe you as we will be either considering that section 42A or not, but you should be advising us in terms of the consultation with the public, how we will go about that. Maybe you can advise us in the next meeting in terms of the process when we consider whether we should agree to it or not to agree to it. Thank you so much. Back to the department.
Chair, can I come and assist also? My colleague will take some of the questions. I think I would want to deal with the question that you've asked, the last issue of double jeopardy that was asked by, I think, Busa or Busa. Now, Chair, double jeopardy has got nothing to do with different legislation. It's about whether you are punished twice for the same offense. That's the issue, whether it's the same legislation or not. Now, let's look at different legislation. If a company has been arrested, has been charged for corruption, in whatever legislation that they were involved in, that company can still again be listed in the National Treasury list to prevent it in tendering. Secondly, if a company is not complying with tax regulation and SARS take this company to court and the court take its process, that company will still be prevented if it does not have a tax clearance certificate to get any tender in government. It won't, even if it's not listed, it won't be able to tender for government. Now, what I'm trying to explain in this question, Chair, that you're asking is that there is many legislation that does exactly the same. The BE Act, it's a BE Act. If you don't comply with the BE Act, you don't get a certificate. And it punishes you for that, for not complying for that in another legislation. Now, from where we're sitting, we really don't think that this is anything new. As I've said, if you look at the SARS provision and the SARS Act, you look, if you contravene that, you can be punished in terms of the Procurement Act. You might not be able to procure with the state when you've contravened the tax legislation. And that's the same arrangement that we're dealing with here. I think the other issue that I want to deal with is our argument in all of these cases is not only about the fact that it was discussed at NetLab. That is an addition that we're putting in front of the committee. But if you look on our presentation, we're putting reasons why we do not agree with many of these issues that are being raised. For example, the issue of whether should the law look at reasonableness and say if you've shown reasonableness in applying the law. We say the law already says that an employer can give a justifiable reason for not complying. Now, why do you want to change that? And the regulation publishes the set of justifiable reasons that you can select with. And I think my colleague can answer the issue about the commission, whether the commission was consulted, the issue about targets and quotas, in terms of those two questions. Chair. Thank you, Chair.
Thank you so much, Mr. Mkalepi. Any further responses from my other members of the team?
Thank you, Chairperson. Thanks, Mr. Mkalepi. I'll start first, Honorable Chairperson, with the issue of the commission and whether there was consensus by social partners that the pace of transformation of the labor market is very slow. First, honorable members, is that the Commission for Employment Equity is consisted of all social partners at NetLab. And they are the ones responsible or mandated by Section 30 of the Employment Equity Act to look at the data submitted by all employers in the different economic sectors, analyze it, and compile a report and submit it to the minister reflecting on the employment equity status or the pace of transformation in the labor market. After the minister releases this annual report, honorable members, it is also tabled at NetLab again in the labor market chamber to update and give feedback to all social partners that some drastic measures must be taken, seeing that the pace of transformation of the labor market is very slow. At most, honorable members, since 23 years of employment equity, the progress has been at least at 2% annual. Hence, we haven't actually shifted in terms of transforming the economy in the 24 years of employment equity. Therefore, there has been discussion on this matter, not only in the commission itself, but also at NETLAC, to appraise all social partners that we must do something to ensure that the economy or the labor market is transformed. And hence, also these amendments that are being discussed in this committee were actually first discussed by the Commission for Employment Equity, and they are the ones who actually advised the minister that steps must be taken by the government to see how we can actually expedite transformation. Hence, these proposed amendments, they are actually coming from the Commission for Employment Equity. So they have been engaged, they are sponsors of these amendments because it's their mandate to actually advise the minister on any EE policy-related matters. The second issue, Chairperson, you requested that I clarify again the differences between quotas and targets. The difference is that if there is a quota, for example, the minister says at top management, you should have, out of 10 people in top management in your organization, 50% of those should be African. And you must have 50% of Africans in 5 years. And if you don't have 50% of the 10 people at top management in 5 years, we are going to refer your non-compliance to the Labor Court for a penalty. And you are not allowed to provide any justification or reasonable reason why you were unable to reach the 50% Africans in top management. It doesn't take into account the fact that maybe out of the 10 people that are in top management, 9 of them are white males who are not going to retire in 5 years. Then it's a rigid quota. You are going to be punished for it. It's compulsory. There's no flexibility at all. Whether those people resign or retire in 5 years, the quota simply means that you need to fire 50% of those people in top management. Out of the 10, you must fire the 50% to make a space for the 50% Africans. That is a rigid quota, which is not allowed by the Principal Act in terms of Section 15.3, which I alluded to earlier on. However, targets are aspirational goals. Although employers must strive to achieve the target, if the minister says in 5 years at top management in this sector, we want to see 50% Africans, honorable members, there is flexibility that is given in this proposal that to reach the 50% in 5 years for top management, the minister says you must go back and do a workforce profile analysis. Check who's sitting in your organization in this sector in top management. And in consultation with the employees, determine how you're going to reach the 50% when opportunities arise. We must remember that employment equity works on opportunities that may arise. It doesn't say people should be dismissed and make space for those that are underrepresented. We are looking at the growth of the company because the economy is growing. There will be more recruitment opportunities arises, and we are saying utilize the natural attrition in your company to reach the 50% in 5 years. Meaning, Chairperson, that on an annual basis, you do your own self-regulation based on what you have and whether you anticipate that there will be opportunities, job opportunities where you can bring more African people in your top management in 5 years to reach the 5-year regulated sector target. If the economy is not growing or your company is not doing well, you will not be able to recruit more people. And because the law doesn't allow you to dismiss people, you can raise a justifiable reason that the economy was bad, my company didn't grow, therefore I didn't have sufficient recruitment opportunities to bring on board more African people in top management. Hence, we are saying targets are flexible. I also want to bring the alignment between the sector target and the EE targets. I've also alluded, Chairperson, that because the minister will regulate for a sector after consultation, maybe a 5-year sector target, that I want to see top management to have 50% of Africans in it. Employers are given flexibility to go back and look at what they have in their workforce and what opportunities will arise in the 5 years to reach the sector target. In consultation with their employees, they will say, to reach the 50% African in 5 years, in the first year, we are not going to have any opportunities because we don't anticipate any growth. But in the second year, we are setting a 20% target for Africans, meaning that if there are any opportunities arising at top management, if people may resign or retire, will actually target African people at top management so that we work towards the sector target. And they will do so for the 3rd year and the 4th year, which takes them a step forward to reaching the 50% Africans in top management. And this annual target, Chairperson, that are consulted with employees will then be included in the EE plan towards the 5-year sector target, so that on an annual basis, they are being assessed on how they have actually achieved their own annual targets towards achieving the 5-year sector target. And a certificate will be issued to them on an annual basis. And if they are failing to actually reach their own annual targets, they can then raise a justifiable reason that the COVID-19 came in, the economy didn't do well, there was shut down, and we couldn't actually have any recruitment opportunities to bring in anyone on board into our company. Then they will still get the certificate, but because all of us are aware that the economy was hit hard by the pandemic. So I think I've clarified the linkages between the E plan, the consultation, and the annual targets, and the sector targets that will be regulated by the minister. I thank you, Chairperson. I think we have covered all areas.
Yeah, no, thank you so much. Because I just wanted clarity on that, because there could be a difference between a sector and the workplace. You could reach the target in the sector, but it doesn't necessarily mean some of the workplaces within that sector have reached that 100%. So that's why I wanted clarity on that respect. When you talk about sectors, because you could get 100% or 90% in the sector, and yet within the sector itself, there will be workplaces that are still at 20, for example, but under the umbrella of a sector, they've reached 99%. So that's why I wanted this alignment. What does it mean? Would you say because that sector has a 99%, and therefore all the companies that are under that sector have then complied on the basis that you're dealing with sectoral targets, not necessarily workplace targets. Honorable Dango?
Chairperson, based on the question you've just asked, will this provision stand up to constitutional muster, or will there be a myriad of court cases taking place over time?
Okay. Maybe if we can get a response to that, because that's one, especially in that area, there were always those issues that were raised about the constitutionality, especially Section 53. Any response? Are we confident that these provisions are constitutional?
Thank you, Chair.
Maybe just a follow-up on that, Chair.
Yes.
Yeah, because look, you get a sense that from last week's presentation, they agreed that there's a need to fast-track transformation, but they have amended their making is that Section 15A undermines the Constitution, therefore it is unconstitutional. It undermines economic growth and employment creation. Maybe just in addition to the question raised by Honorable Tango, what is the department's response to that?
Mr. Mkalepi, we're coming in.
Thank you, Chair. I mean, our view is that first is that we will never be able to stop any court challenge on our legislation. There will be court challenges. And employment equity is a very contested area. Any transformation legislation is contested in this country, precisely because you've got people who are beneficiary of privilege who wouldn't want to let go. And you've got people who do not have those privilege who would want to have them. That's what employment equity is about. Therefore, I can't guarantee that there will be no challenge. But we are confident that this bill will stand any challenge. In drafting this bill, we had sound legal advice on it, on how to craft it. The legal advice started at NETLEG. At NETLEG, when we were negotiating, there were legal advisors there. When we were drafting the bill with the commission, there were legal advisors that were working with us, supported by the ILO. We asked the ILO to come with us and work with us on this. Therefore, we're confident, but we can't give the committee a guarantee that there will be no challenge, not with employment equity. We're definitely sure there will be challenges, but we're confident. It went to, as we indicated, to the state law advisors. The state law advisors look at it, they satisfy it, and the legal advisors of Parliament have also looked at it. They see nothing wrong with the bill. But we can't say that there will be no challenges, Chair. There will be challenges, and we'll have to take those challenges. And sometimes court challenges enriches legislation and policy, and we should welcome it. The Barnett case, when it came out, it enriches the implementation of this of transformation, because it may clarify all the issues that were not clear in terms of the threats of constitutionality. The sooner a constitutional challenge comes, the better for all of us, so that we can have clarity upfront on the issue, so that we don't live with this, that people continue threatening that they are going to go to the constitutional court. And then therefore, Chair, for us, we are really confident. But I mean, you can never be sure in court. You can't say, even if we say we're confident, I mean, there might be something else we don't know. But from us, we think it has covered all the bases.
Thank you so much, Mr. Mkalepi and Ms. Tswaki. Can we go then to the next bill, COID Amendment Bill? I don't know who's taking us through.
William Afata will do it.
Yeah, so he's a co-host there, so I assume that he's the one who's taking us through. And it's a long presentation.
Thank you, Chair. Thank you, Chair. It's a long presentation, Chair, but it will not take long. Some of the slides will just speak through them. We take it that the honorable members have read the presentation. Thank you very much for the opportunity to be able to respond, Chair. Chair, if you don't mind, can I keep my video off? I'm in a load shedding lane here, so I don't want to affect the network.
Yeah, no, that's fine. Yeah, that's fine.
Okay. Thank you, Chair. So I'll do the first part of the presentation, Chair, quickly, and then my colleague, Mr. Herima Pologera, will then take the committee through some of those specific points in the presentations that we're making recommendations on some of the wording in the bill. Trying to just move on the presentation. Apologies. So our response, Chair, will be around 4 areas. So focus on there was a lot that was said around the socio-economic impact assessment study. So we'll be briefly reflecting on that and the position of the department on that. The issues around, so in support of some of the presentations that were being made or comments or inputs that were being made by some of the stakeholders, they made some statements around the lack of rationale for some of the amendments that we're making, owing to the fact that our turnaround time when it comes to payment of claims is excessively long, and hence they are not recommending for the committee to process this bill. So we just want to rebut some of those statements with some of the statistics that we'll be showing the committee. And we also then would also have more specific comments on the one section of the bill, which is section 73, the amendment to section 73 by inclusion of subsection 4 and subsection 5. We just want to comment a bit more in detail because that is a major, or what was seen as a major amendment from the side of the stakeholders that commented, and they had a lot to say about it. So we just wanted to give the rationale for what was the reason for the initial amendment that we're making, and also the one that has now been settled on, that was published as part of the bill approved by the National Assembly, and the rationale for why we see it fit for this subsection 4 and subsection 5 to be in the bill, and the evil that it's trying to address. And then we'll then lastly focus on some of the specific issues that have been recommended for inclusion or amendment or omissions. So we'll then reflect on that. That's what Mr. Mapologana will take the committee through. So starting with the socio-economic impact assessment study. The socio-economic impact assessment study is an instrument that was developed or adopted by Cabinet for government, for any proposed bill or policy that government will take out to the public. There is a requirement that this internal government process be conducted. And this is conducted with the assistance of the Department of Planning, Monitoring and Evaluation. And before we can table any bill to Cabinet, be it we're tabling the bill to request approval to go to NEDLEC for engagements, or whether we're publishing the bill for comments post the NEDLEC process, it is a requirement that it needs to go through the SAYAS. And the COIDA amendment bill is no different, contrary to what has been said. And there is a template that has been set by the Department of Planning, Monitoring and Evaluation, which is the template that was complied fully by the department and completed and signed off and presented with the bill together to clusters of the DGs before the bill was presented to Cabinet, and also when it was submitted to Cabinet, that SAYAS report was part of that. And there is no legal requirement for us to publish this SAYAS report, save for the bill itself that we are proposing to the public. So we conducted this in 2018, 2019, and we then finalized the bill after having done this socio-economic impact assessment study with the Department of Planning, Monitoring and Evaluation. And as part of the process of developing doing the socio-economic impact assessment study, we also consult internally with government, within government, with various government departments whose areas of operation would be influenced by the bill, and those that can contribute and input into the bill. So we do wide consultations internally. Beyond the socio-economic impact assessment study, we also did consultations on the bill itself. So after the Cabinet had approved the bill for submission to Cabinet, we actually did, and also post the discussions in NEDLEC. We published it for comments, and we also had specific public consultation processes across all provinces, inviting all stakeholders to come and present and give their inputs in terms of the bill. In fact, we did this before we even went to cabinet with the final bill. And when we came back from cabinet, it was ready to be submitted to the National Assembly to be processed. So all the inputs that were taken as part of the consultations were taken into account in developing the specific clauses that are in the amendment. In fact, some of these is a result of those consultations, the inclusion of domestic workers, as a result of those consultations that the minister had conducted with the sector before. We also took into account some of the issues around the no-fault clauses that are in the bill. But as a result of talking to organized labor and many other, those that are in the labor market, with trying to see how we can further improve and remove some of the bottlenecks that are currently leading to a lot of repudiation of claims. So things like those were considered after having received those inputs from the members of the public. I mentioned the departments that we consulted with. Chair, I'll just flip the slide. And we also, I think in keeping with also the cabinet decision of March 2009, we also submitted the bill to the Office of the Chief State Law Advisor before we were even ready to submit this bill to cabinet. Chair, when we look at I'll just touch, I will not be detailed on this presentation, Chair. The numbers are there in the slide, but just talks to some of the issues that have been raised in the presentation in terms of our performance. Now, Chair, a lot was said around the rationale why certain stakeholders exist in the COIDA process because of the fact that the compensation fund takes a number that was mentioned. There was about 241 days to process and pay medical practitioners' claims. So this slide just shows if you look at, and just in the last 5 years, in terms of the performance targets that we had set ourselves for each of the financial years. In 2016-17, for example, the performance indicator that we had set for ourselves was that all medical invoices would be finalized and paid within 60 working days, or 85% of them would be finalized within 60 working days of receipt from the medical practitioner or those that represent the medical practitioners. And if you look at the performance, we're able to do 89% of all medical invoices that we had received. Then you'll see the quantum of the volumes as well as the amount of medical claims that we receive. We're able to be paid within 89% were paid within 60 working days. If you look at 2017-2018, this was increased to 93% of all claims received will then be finalized and paid within 60 working days if a claim is rejected, and also that decision would have already been known by the medical service provider by then. And in 2019-2020, we actually went further and reduced the turnaround time in terms of days. From 60 days, we then reduced this to about 40 working days. Right, and this is the year in which we implemented our new system. We also had a freeze on payments for a couple of months, and hence we could only pay 69% of claims within the 40 working days, with the remainder of the claims being paid outside of the 40 working days, but still less than the 341 days that has been mentioned by one of the stakeholders. If you look at the last financial year that we've just come from, still the target was about 85% of claims paid within 30 working days. We're able to do 93% of these claims within the 30 working days. Then this slide just shows you the numbers in terms of the volumes of medical claims that we receive versus those that we're able to process within those financial years. And you can see in the last financial year, we just fell shy of 1 million invoices or medical claims that we've received from medical practitioners that we had received, and 867,000 of these were processed within 30 working days and paid, which makes up that 93%. Then this just shows also the number of registered claims that we've received over the last financial year. And we're highlighting these numbers also just to show, because a lot of some of the presentations were referring to some of the inefficiencies of the fund and inability of the fund to be able to implement its mandate, hence the rationale for certain of the practices that the fund was seeking to regulate was being made. So this just shows the numbers. You can see that almost 160,000 claims that we've received That is the claims of the injured workers. In the previous slide, we were showing for these 160,000 injured workers, we received 900,000 medical claims for them. So this just shows the rand value. You see that we've paid consistently around just over 4 billion rands in medical claims for each of the financial years over the last 6 or so financial years, with the last financial year being about 4.1 billion that we paid, made up of medical benefits of about 2.8 billion, or compensation benefits of 124 million, as well as the pensions that we've paid of about 1.2 billion. So when you talk to this number of 124 billion, if members can just bear in mind of this number, there is some slides later on where we'll show some of the problems and the challenges that we're trying to resolve by trying to regulate some of the conduct of or even those that deal with the compensation fund to submit claims on behalf of those that are injured. Chair, when we go to so that was just to show the numbers in perspective in terms of the work that the compensation fund has done over the last few years. If we go to the next section, this next section just talks to our response on the amendments to Section 73. This is an amendment that was met with many objections, and I think resulting in the amendment the way it is now in terms of the regulation, the minister's ability to be able to regulate some of the third parties to ensure that when they do interact with the fund on behalf of the stakeholders of the fund, or the key stakeholders of the fund to be the employer or the medical service provider, they do so within the rules that have been set and in compliance to the relevant legislations that govern the work that we do in the compensation fund. So these third parties that also have been presented, they then say they represent both employers and medical service providers. And I think the claim made is that they are assisting the fund to carry out its mandate. So one of the things that we will be taking the select committees, apologies for the word portfolio committee, is to make sure that we just show the legal basis and the framework under which these third parties operate, as well as the legal framework in which the fund operates, which influences some of the policy recommendations that we are making. So the fund derives its mandate, number one, from the COIDA Act, which is a Schedule 3A public entity, and we are then required as a public entity, we're then required to comply with the Constitution of the Republic of South Africa. And also, secondly, we need to comply with the Public Finance Management Act, which is the supreme act in terms of the administration of many state institutions. And so we operate in highly complex regulatory environment, over and above the 3 legislations that I've mentioned above, and many other legislations that affect the kind of work that we do, and I'll touch on that in the next slide. So we have many departments that influence and impact in the way that we work. The Department of Home Affairs, the Department of Health, other public bodies such as the CIPC, the South African Revenue Service, the Department of Health through the Board of Healthcare Funders in their role in administering the practice code numbering system on behalf of the Council for Medical Schemes. We also have the Health Professions Councils, which also regulate the conduct, as well as those that are entrusted with the responsibility of providing medical care to those that are injured in the workplace. And many other public and private bodies that we have some of the requirements that we need to comply with. So, and lastly, and most importantly, is that, so we also have the National Health Act, which is an act that regulates the health system in the country. So particularly Section 14, 15, and 16 of this particular act has a direct impact on the work that we do as a compensation fund. And obviously, lastly, also the POPIA Act, which just came into effect, which also places the legal protection onus on us to be able to ensure that any person whose data we deal with, we maintain the confidentiality of that particular data, including those that are injured at work, who, in terms of the National Health Act, are defined as users or patients. So if you look at the role players in the whole COID scheme, so the center always has to be the injured worker. If I make an example with this particular graph, so the center is always the injured worker. So if you look at any point in time when an injured worker gets injured at work, the injured worker is expected to report a claim to the employer. The employer would then send the employee to the medical service provider, which is on the left-hand side. And then also together with sending the employee to the medical service provider, he or she then needs to send the relevant forms with the worker. If not able to send them with the worker, they need to be sent still to the medical service provider, which the medical service provider needs to complete. And once the medical service provider has completed, either sends these things back to the compensation fund or sends them to the employer, right? And once we receive these, we're then able to make a determination and assist while the worker is being assisted with medical treatment. We communicate what the claim number is to the medical provider and also to the employer. And we communicate what we need to communicate to the medical service provider in terms of our liability decision and also to the registered employer. And once there's any issue or any information that we need from a medical provider, we're then able to go back to the medical provider to request such information. And if the information is already provided to the employer, we're able to then ask for that information from the medical provider. And we then communicate the claim numbers as well as any decisions that we make and payments that we then would have made either to the employer for temporary disability payouts, because the employer in such cases pays the salary and then we reimburse the employer. And if we've made a decision on the permanent disability of the worker, then the payment that needs to go to the claimant will then be made directly to the claimant. So now, these are role players which you would find in a COID claim, and these are the only role players that are being referred to in the legislation, in the COID legislation. So when you look at the regulatory environment within which these role players need to play, you can also see that there's specific requirements that each of these need to comply with, and they comply with these things to maintain integrity and to make sure that the ethical conduct of each of the parties in the role that they play in assisting an injured worker or a patient in South Africa, that they do so within the ethical boundaries and requirements that have been laid down by law. If you look at on the left-hand side, the healthcare providers, we've got the Department of Health, which would be regulating the conduct of healthcare providers through the licensing that they provide to the healthcare providers. You also have the practice code numbering system, which is administered by the Board of Healthcare Funders, who do so on behalf of the Council for Medical Schemes and regulated through the Department of Health. You've got the professionals themselves, those that are treating workers, have an ethical code of conduct that they need to comply with from the Health Professions Council of South Africa, as well as many other association or voluntary associations that they belong to that represents those professions that they belong to. So no medical provider can claim from a medical aid nor from the compensation fund if they don't, for example, comply with the requirements from the Board of Healthcare Funders in terms of the practice code number that is offered through by the Council for Medical Schemes. You also have the compensation fund itself, which is bound by legislation within the government, Department of Labor, and set legislation in the form of the COID Act. You've got the National Treasury, which also then comes in with the Public Finance Management Act and the Treasury regulations and so on. So, and the employers themselves, who over and above even to comply with whatever requirements or licensing requirements that they are required in terms of the industries they operate in, they also require them to be registered with the DTIC in terms of the Companies and Intellectual Properties Commission and many other regulatory requirements. So you can see these role players that I spoke about earlier on have a specific legislative and specific codes of conduct that they need to comply with, which regulate and govern the way that they operate. And in both these instances, I have not even mentioned once any of the third parties that who then say that they're playing a role in assisting employers and medical providers and so on, and are critical for the administering of the COID legislation, because they aren't governed by any standards or any other industry body that we are aware of, which ensures that they maintain a certain level of ethical conduct and so on. So now, if you look at the type of third parties that we have in our environment, so we have multiple third parties. We know that employers, or most employers, would choose to outsource certain administrative activities, which is a practice that is applied across many sectors and for different things. So, and we do in our business process take into account this particular fact, and we've built and designed our system to accommodate this particular fact that some employers would not choose to do certain administration themselves, and they'll outsource this administration to somebody else. So we should look at some of the examples that we have in terms of those that are in our environment. Because switching houses were appointed by medical service providers themselves to use the technology that they have developed to help them to submit medical claims to the compensation fund. You saw we receive about 900,000 medical claims. That's huge volumes of medical claims. In most cases, a doctor around the corner may not be able to have the muscle to be able to have an administrative system to administer these things on their own, because they don't only claim from the compensation fund, but they also claim from other medical aids. So they will then choose to utilize a switching house to be able to help them to submit these claims to these healthcare funders, such as the compensation fund and others. And this would then be based on the rules that that particular funder, healthcare funder, compensation fund, or any other medical aid would have set for the submission of such invoices. And then once we receive such invoices, we then process them as the invoices from the doctor and pay the doctor directly or the healthcare provider directly, if it's a hospital or any allied healthcare practitioner. The second form of third parties that we've interacted with in our environment are practice managers. So same thing, where a medical service provider may not want to manage their own practice, but they would choose to outsource and focus on their core job of treating clients. And in such cases, they may then use this facility practice manager to manage their practice, and such a practice manager will then, on behalf of the doctor, enter into a contract with the switching house, and the switching house, working together with the practice manager, will then administer all the claims that the doctor submits to the compensation fund or to any other medical aid. And then we then pay. Once we receive that, the owner of the claim is still the doctor. He's just appointed these two parties to be able to help him or her to submit claims. And when we pay, and the obligation in terms of the treatment of the clients and any responsibility towards the client. And COIDA places not only the responsibility to treat the client, but also to submit specific information to the fund. That still lies with the medical provider, and the medical provider still then gets paid directly by the compensation fund. Then you have also the third type of third parties, which is the third parties that have presented before the committee here. So these are third parties that, so in fact, this is, before I get to those ones, there's these third parties that would also then be appointed by a medical provider to also do administration, receive claims, submit the claims on behalf of the doctor to the fund or to any other person based on the rules. And then we then still continue to pay the medical provider directly as well. The last ones, which are pre-funders or other third-party agents, which are the ones that I presented to the committee before in the last session. So these are third parties who do things slightly different. So they pre-fund doctors, or pay, that's the word they use, to pre-fund or procure. But in the legal sense, they basically procure the claim of the doctor from the doctor and submit this claim to the fund based on the rules of the fund. And then in this case, the fund would then pay back this particular third party because they own the claim, right? And in most cases, what we've seen with this, they would also then do the same responsibility. They would also take responsibility of registering the claim that the doctor has sold to them, to the fund, because without a claim being registered, they're not able to even get their claims through and ask to accept liability to pay for this. So, and one of the things that and in most of the cases, there's major challenges that we find in this particular practice, because the interest is never about the claim of the injured worker himself, but the interest is about a doctor or a pre-funder recovering their money by getting paid by the compensation fund because they've got this claim. So what they do is enough to be able to make sure that the medical claim gets paid, but is never sufficient to ensure that the injured worker gets to see his claim finalized and paid. And in most cases, then the worker is found in the limbo because the medical practitioner has received his money from the pre-funder, the pre-funder has received his money from the compensation fund, and then the worker is left to fend for themselves in terms of seeing to it that their claim is being attended to. So with the amendment of Section 73, we're actually, with the inclusion of Section 4 and 5, we want to be able to the minister to be able to regulate some of the conduct that these third parties with regards to their role that they play in the claims, to make sure that there is control and regulations that they have to comply with, so that all parties who are party to benefit from the COIDA legislation do indeed benefit, and it's not one-sided currently as it is. If you look at I spoke about the compliance requirements in my earlier slide, and this just highlights those in terms of a medical provider must be regulated by the National Health Act and its regulations, and in order to claim from a healthcare fund, and a healthcare funder is any person who pays a medical bill. It can be a medical aid, it can be the individual person, and so on. And they cannot claim if they're not registered with the practice code numbering system that is managed by the Board of Healthcare Funders on behalf of the Council for Medical Schemes. And the National Act also defines what is an authorized institution, what is healthcare personnel, what is a healthcare provider, what is a private health establishment, and what is a public health establishment, and what the legal responsibilities are. And once again, the National Act focuses and gives those definitions in terms of those role players that are, in terms of the COIDA Act, are also required to treat those that are injured at work. And if you see here, the third parties that I've mentioned earlier fall outside of the ambit of the National Health Act, even including the Council for Medical Schemes. There is no regulatory oversight over these parties that is able to ensure that their conduct is within the ambit of the law, as well as it's in the interest of the public that are meant to qualify to benefit from the legislation that legislators have put out. And if you go to if we look at some of the legal challenge in terms of this whole practice of seeding of invoices and to third parties. So the National Health Act, Section 14 of the Nation talks about confidentiality in terms of keeping the information of a user. Now, a user is any user of the health system in the country. So a patient is a user as defined in the National Health Act, right? So any information related to his or her health status, the treatment, or even their stay in the health establishment is confidential. So in terms of Section 15, it says that no person may disclose such information, right? Unless the user consents to that disclosure in writing, unless there is a court order or any law that requires that disclosure, and also if the non-disclosure of the information represents a serious threat to the public health. I'll show in the later slide how this applies to the compensation fund. And if you look at Section 15, it also talks about the health worker or any healthcare provider that has access to health records of a user may disclose such information to any other person as is necessary for any legitimate purpose within the ordinary course and scope of his or her duties, where such access or disclosure is in the interest of the user. And once again, the user is the patient or the person that is being treated in the healthcare establishment. And the personal information that is referred to in the National Health Act is the personal information as defined in the Promotion of Access to Information Act of 2000. And if you now look at that and you look at the fact that the invoices that the healthcare provider has to submit to the compensation fund has to then comply with the requirements as laid out in the regulations of the Medical Schemes Act. And the the Medical Schemes Act and its regulations actually prescribe what must be in a medical invoice that is submitted by a healthcare provider to a healthcare funder or payer that he must pay. And if you look at it over and above the normal biographic information in terms of names, details, and so on, the practice code of the doctor, if you look at point number F, the relevant diagnostic and such other item and code numbers that relate to such relevant health service. Right? So if a person is sick and is treated by a doctor, there's specific clinical codes that a doctor would then show in the invoice to show that this person was treated for this and for that and for that. And these codes are then used by healthcare funders such as ourselves to be able to know what this person has been treated for. And these are codes that are available on the internet, published by the World Health Organization. So also if you look at GH, the date in which this was rendered, the nature and the cost of each item, where a pharmacist is going to supply medication according to a prescription, So all these other things that need to be mentioned, and these are all the things that an invoice needs to comply with. So if you look at an invoice that structure and format that we've issued, that we've published as the compensation fund that a medical provider needs to comply with, complies fully with these requirements of the Medical Schemes Act and its regulations. Above is just an example of a medical invoice as it appears on our system, for example. And if you look at some of the item, if you look at the item that I've cycled here in the middle of the invoice, it just shows you the diagnosis code, which is S82 V49.82. So if you go to the World Health Organization website and you download the ICD-10 codes, when you go and check this particular ICD-10 code, you'll be able to see exactly what was the diagnosis of this person who whose invoice is being submitted to the compensation fund. So if you look at some of the items that I've sort of like blocked out, is the claim number. It shows the name of the patient. It shows also there's who's the doctor that was treating the patient, what's the name of the patient, the ID numbers, and so on. So this is the invoice that would then, in normal circumstances, if a doctor chooses to sell his right to a claim to somebody else who's not regulated, then this person then has all this access to this information with whoever that they work with, and then they're able to process this claim and submit it to the compensation fund as if it's their own. Bearing in mind the specific requirements in terms of the National Health Act to keep the information of a patient or injured person or who's now a patient in a healthcare establishment confidential, and only doing it to another provider who is assisting with the well-being of that particular health worker. So you can already see problem number one in terms of the challenge that this practice poses. And if it's left unregulated, it becomes a bit of a challenge with regards to what other purposes this information of an injured worker could be used for. So if you look at secondly, I think over and above the legal challenge, you also have operational challenges that the use of third parties also would impose, which requires the need for this relationship to be regulated. If you remember the previous slide that I showed in terms of the operational challenges, in terms of the role players in the COID scheme, with the third parties involved, with most employers and or medical practitioners that uses the third parties, you often find a situation as is depicted in this slide. If a person is injured, the injured worker being at the center of this diagram, they report the injury to the employer on the right, and the employer then sends the employee to a healthcare facility for treatment on the left-hand side, and they would send this information, send the forms and the relevant information to the healthcare practitioner for them to complete what they need to complete. And once they've completed that, instead of the chain continuing either with the medical practitioner sending the information back to the employer or sending the information to the client, you find a situation where they treat the injured person, but the information gets sent to a third party away from the fund. And the third party is the one who sends the information to the compensation fund based on the information or the claim that they would have procured from this particular healthcare practitioner. And in most cases, you find that because these are the people that communicate with the fund, when you're communicating information back to the injured worker or to the employer, try and make sure that you get whatever outstanding information. The people that you're able to contact are the third parties. If it's not in their interest for this particular claim to be finalized further, but they have been paid what is in their interest, which is the medical invoice that they've procured from a medical practitioner, then the information that you're requesting from an employer in respect of this particular injured worker will just lie there in a black hole and not go anywhere. You often hear complaints from workers who say, I was injured many years ago, my claim was never attended to. Most of these workers, you find that they went to a healthcare facility, they were treated. The healthcare practitioner was paid, but the injured workers' issues were never finalized because that information ended up somewhere in a black hole on the bottom screen here. So, and these are some of the operational challenges that if some of this conduct is not regulated, it continues to keep this, and people that end up suffering is the injured worker when everybody else has been able to to benefit the worker. The employer has discharged his responsibility in terms of making sure that the claim gets submitted and registered, the person gets sent to a medical practitioner, but the injured worker himself is left in the limbo because there isn't anybody who is making sure that his things are attended to, because even when they do get sent, they get sent to a person who doesn't have any interest in the making sure that this particular person benefits and gets what is due to him in terms of the law. So just to highlight the challenge that I'm talking about in terms of the outstanding information, and I'll not spend time on this, any person who gets injured, there is a fully completed form that needs to be completed by an employer. When they send this information when they send the employee to the doctor, on the same form, there's information that the doctor needs to complete. That's which is the report that will be used by the fund to make a decision based on the notice of accident that the employer has submitted and the accident report that the employer has submitted, together with the medical report from the doctor. We're then able to make a decision whether this is an injury on duty and we accept liability for it. Accepting liability is important because it then opens up a credit or a medical facility for this doctor, for the person to be treated at a facility, knowing that the compensation fund then takes full responsibility for all the costs of such treatment. So if we've not accepted liability, you have a situation where the worker can still be treated, but then either the employer or the worker himself will then be required to pay the healthcare facility because nobody else has accepted liability for this particular claim. So that is why it's important to get this information in full to enable the fund to be able to do so. And oftentimes, if I just go to this slide, so this is the form as it shows. So you have the first part, which is specific, must be completed by the employer. You've got the second part, which is specific, must be completed by a doctor. And there's a specific part that would then need to come to the compensation fund. Oftentimes, you find that if this claim comes through a third party, specific part that relates to the accident and the responsibility of the doctor in terms of the first medical report will be completed in the report. But the rest of the information that is required, if you look at this form, has a number of pages. The part that should be completed questionnaires that enables us to assist the injured worker to take the claim further over and above paying the medical provider. If that part is never completed, it means you end up with a situation where you've accepted liability for the claim, you've paid the medical practitioner, and because certain parts are blank, because it's not in the interest of the third party to follow up the employee and say to him, this information is missing, you need to complete it or you need to submit it, then you find a situation where the worker is in a limbo and then often waits a number of years to get his or her claim finalized so that he can get closure and whatever is due to him in terms of that claim. I think so as I indicated, as I conclude and allow for Mr. Mapologelo to just continue with the specific issues related to the inputs that were made on specific clauses. So if there is a break in the chain in terms of the specific role players and claims are submitted by people other than those that are authorized to, right? We are unable to then be able to assist the employer speedily. And then this whole legislation doesn't become then in the interest of the injured worker, but interests other parties except for the primary person who's supposed to benefit from this legislation in terms of the ILO standards, which is a worker in this instance. And that's largely the reason why we want to make sure that the conduct of everybody who operates here does comply to a specific standard and the person can be held to that particular standard. And if there's non-compliance, there are consequences to that non-compliance to the standard that has been agreed and set for each of the role players. Chair, I think maybe just lastly, if you look at, I made a point earlier on that, for example, in this whole process, you find that people that end up benefiting more from a COID process than, it's not the injured workers in the main mostly, it's mainly the healthcare practitioners who would then have their issues sorted. And the healthcare practitioners play an important role in making sure that workers are treated and those that are able to get back into employment, they do get back into employment. If we look at just looking at the 2020-2021 financial year, you would see that almost 2.8 billion comprising of about 644,000 invoices, was paid to medical practitioners. It was processed to medical practitioners. And during that year, we had registered about 160,000 claims, and liability for about 89,000 of these claims was accepted. But when you look at what we eventually were able to pay in that financial year, because you have all the information and you're able to finalize the claim in that financial year, was only 43,000 claims out of the 160,000 claims. And we were only able to make a payment of 267 million. It's almost 10% of the value that you paid in medical costs to the injured worker. Now we know that the amount in terms of the claims that we paid to the injured workers will never be the same as the ones that we pay to the healthcare providers because of the cost of medical treatment. But you expect the quantum as well as the volumes of claims that you finalize and pay to be higher and up there with those that you have received, as opposed to this process of waiting long. And in the same process, we've paid this 2.8 billion that we have of 644,000 medical invoices to practitioners. So up until such time that we make sure that the worker becomes the center of any compensation claim, we will continue to have scenarios like this because the interest of the workers, though there are many others that claim to be representing the interest of workers in the space, but the interests that they truly representing are those of third parties as well as some medical service providers who are working with these third parties. If I just then maybe just go to Mr. Mapologela on the responses on the proposals for the inclusion and amendments as we draw towards concluding our presentation. Mr. Mapologela, over to you.
Good evening, Chair, members of the committee,
Good evening.
the officials of the department, the Office of the Chief State Law Advisor, the attorneys for the committee, and the staff for the committee. My name is Harry Mapologela. Chair, you would notice immediately that we didn't mention the names of the stakeholders who made submissions to the committee, and we only dealt with the substance of their submissions, on the understanding that the committee will be in a position to link after juxtaposing our responses and the submissions. Without wasting time, Chair, I will start with the submission that was made on the definition of accident, which is section 1. The actual submission is that an accident or occurrence arising out of, now look what comes next, or in the course of an employee's employment and resulting in personal injury, illness, disease, or the death of the employee. If you look at that, and has been replaced with or. Now, let me state this up front. There must be a causal link between employment and between occupational injury or occupational disease, because we compensate for disablement or for death caused by occupational injury or disease. So if you read it the way that the lawyers read it, it would mean accident means incident or occurrence arising. Actually, it means incident or occurrence arising out of employees' employment and resulting in personal injury. Then you'll have the second link. Accident means an incident or occurrence in the course of employees' employment and resulting in personal injury, illness, occupational disease, or death of the employees. The two elements must be there at all times. You can't be separate the two. It can't be or. It must be always and. Let me give an example of a nurse who treats a person who has contracted a virus, COVID-19 virus. He is employed, is in the course of employment. And then for one reason or the other, without treating the patient, he contracts the virus. You see, there's no link there. But if he contracts it while she's treating that patient who is COVID-19 positive, then you can see the link. There must always be that link. That is what we compensate for. So the removal of that weight will cause problems because then it will delink work from injury itself. Next slide, Commissioner. Next slide, Commissioner. Oh, thank you. And in addition to that, there was a submission that the word occupational must be added before disease, so that it reads occupational disease. That is in fact what is in the bill. I think this submission is delayed in nature because this is what was agreed upon at NETLAC, and it reads exactly like that if you look at the bill as it was amended by the Portfolio Committee. Next slide, Commissioner. And then on the transfer of the Director General Administrative Powers to the Commissioner, there was a submission that in fact there are some inaccuracies as far as the cross-referencing is concerned. There is elsewhere where you still find the word Director General, where in fact you should be finding the word Commissioner. And that is true. I saw one instance of that. But the good thing is that there is omnibus clause which deals with substitution of certain expression in the Act. And the relevant one is there, which is D, I think it falls under clause 62, not section, but clause 62 of the bill. It says Director General, it says by the substitution for the expression Director General, wherever it occurs, of the word Commissioner, except in the following, in the stated sections there. So if by one reason or the other, or by human error, we did not see that we need to replace Director General with the Commissioner where it is appropriate, then this omnibus expression will cater for that. And I must not credit it to ourselves. It was the advice that came from the Office of the Chief State Law Advisor. Next slide, Commissioner. Clause 89, it deals with the amendment of Section 69. There is a submission to say the notice that must be published before you amend Schedule 3. Schedule 3 deals with, I think, percentages or disease. I can't remember that. But it says it should be changed from 30 to 60. But in fact, what is in the bill and what is in the act is 60. As agreed at NETLAC. So I think there was a typing error where, in fact, we were supposed just to delete 30 days notice, but then we used the drafting convention of using the bold square brackets. So it would be my request and the request of the department that this committee rectify that, because it's just a typing error. As it is in the principal legislation is 60 days, as it is in the bill is 60 days. It's just that there is 30 days that is in bold square brackets, which suggest or may create the impression that in fact it was 30 in the principal and now it's changing to 60 because 60 is underlined. On the fines and penalties, the concession at NETLAC, the engagement forum, and the position of the department was that our legislation as it stands needs to be decriminalized. In other words, we need to remove criminal provisions from it and then replace it with administrative fines. Only a court of law is competent to impose fine, and that would link to the offense, where a court takes into account the number of issues before imposing that fine. Rightfully so, the submission indicates that you look at the gravity of the offense, and then you look also at the proportionality of the offense and whether it's deterrent or not. So, but we felt, we agreed at NETLAC that we should replace fines and criminal offenses with just administrative penalties. In other words, where there's non-compliance, the commissioner can just impose an administrative penalty. And we also agreed that it doesn't have to be reflected in the actual amounts, as the submission was saying, to say you must put the actual amount of what you are going to impose as an administrative penalty. But we agreed and settled for 10%. Like the chair said, maybe we were under the impression that whatever is agreed upon NETLAC, it's given. But also it will be foolhardy for us to participate in the NETLAC process and you go back as a department and then you don't take into account what the social partners agreed upon. It wouldn't make sense. So maybe we're under the impression that whatever we agreed upon, it's final, at least for our purpose. But now we understand for Parliament it's not. Or maybe it could have been recorded. I'm not sure. It could have been recorded as an area of disagreement in the minutes. I'm happy that Mr. Mimang said at the later stage they may have to require some records, maybe in the form of minutes or consultation with NETLAC, and then this can also be checked at that stage. And the 10% was just a concession. It was a consensus penalty that was reached at NETLAC. Thank you. Next slide, Commissioner. Section 70. Here we are dealing with rehabilitation and return to work. There is a submission to say, as it stands in the bill, it's not sufficient to ensure that people can work as independent contractors or they can be self-employed, but that it will only restrict them to the work that they previously did. But that is not so. The ambit of Section 78 is so wide that it would include rehabilitating people to such an extent that they can be involved in activities such as being independent contractors, self-employment. You can upskill them. You give what they did not have. You can reskill them. You give them what they did not have. Fortunately, we already have the draft regulation on rehabilitation and return to work. We already have a policy on that. And it talks to these things that I am mentioning at this high level. And then the same organization also made a submission that we must not use the word may, but we must use a mandatory word must or should. When we say the employer may participate in the rehabilitation programs, we say it must not say may participate, but should say must. It must be a must. Well, we opted for this word because there is a provision in the bill that provides for incentives when an employer voluntarily participates in the rehabilitation and return to work, in the sense that the premium that you pay may be less because you would have spent money on rehabilitating your employees and ensuring that some of them, at least, they don't lose their work as a result of, or their employment as a result of injuries or occupational diseases. Thank you. And then, but also, we didn't want to come up with legislation that is accusatorial or adversarial, where you will struggle to get a buy-in. But it must be a reasonable concession. And we believe this is a reasonable concession. On the issuing of the license, the submission was saying there is a concern that because in the future, financial institutions, all of them, will have the option to apply for a license. And chances are that insurance companies would be the ones who would be granted the license because they have been in the business for too long. The concern was that they may use they may decline the claims on technical issues. So that is a fear to say, there's that problem. But our response is, we believe that already the bill, actually the legislation as it stands, it contains sufficient mechanism to deal with that issue, because the minister can impose conditions by way of prescribing them in the regulation. And the DG is also empowered to determine conditions for provisional settlement. This simply means you are a licensee, you are given a license, you can receive claims, adjudicate, accept liability. But it is the DG who must confirm it to say it is final. Before the DG confirms it, it's provisional. Of course, it's not going to be done on a daily basis. There will be intervals at which a licensee will have to, licensee or licensees will have to report to the DG and say, these are the claims that I accepted, or these are the claims that I declined, and the DG may relook at it and say, you must still accept those claims because you repudiated them on technical basis, when in fact you are dealing with social security legislation. And then also the board, because it is represented in a compensation fund, and its role is to advise not only the DG, but also the minister and the commissioner. They can also advise on the conditions for the purpose of proper governance. Next slide, Commissioner. Next slide, Commissioner. And then there was also a submission, maybe before, you can leave it here, Commissioner. There was also a submission that the licenses must be advertised and be acquired by way of open procurement. We agree with that submission. The reason why for so many years they have been going to 2 mutual associations is because the Act is talking about mutual associations, and there are only 2 of them so far. And now let me come to the investment of the funds with PIC. The submission here is that if the commissioner is given powers to invest the funds of the compensation fund without the involvement of the DG, that could give the commissioner too much powers with regard to those funds. But in fact, the DG is the accounting authority of compensation fund in terms of the Principal Act and also in terms of the bill. So there is no way that the commissioner would do such a thing without the approval of the DG, because there's delegation of authority. It goes according to the thresholds of funds. What the commissioner does, in fact, is to do research, do due diligence, and then investigate the portfolios under which the fund may give more returns, and then how those funds can be invested. Of course, the board will also assist because it has got technical people in it. But at the end of the day, is the accounting authority, the Director General, who has got the final weight, and he will also account to the minister. So you can see it's one layer upon another layer upon another layer of monitoring. Next one, Commissioner. Then this is about the amendment of Section 73, which is done under Clause 43. It is actually the addition of Clause 3 and Clause 4. The Commissioner has talked a lot about this. In fact, this Clause 4 and Clause 5, as it stands in the bill now, as it is before you, was actually amended by the Portfolio Committee on Employment and Labor. Ours was out and out ban on session. And there was also a comment to say, before that. Yeah, a consent to say, now if the minister is going to regulate the whole thing, there's a danger that he may actually introduce draconian regulations. Draconian regulations. The minister may do so, but that is only a fear. There is no evidence of that. That is an angelic world of congestion now. We are speculating what the minister can do. In any way, before everything is concluded on the regulations, the office of the Chief State Law Advisor will have to consider the regulations for constitutionality, reasonableness, and legality, just to ensure that it will pass what they call constitutional muster. Therefore, the department does not agree with the submission that says the bill must be rejected. The bill must be proceeded with. It's going to bring stability into the compensation fund. In that now, it will be regulated. Like the Commissioner mentioned, all those things. Some of them, they relate to medical aid schemes. And I believe that medical aid schemes are as successful as they are because they are properly regulated. So we are not that much different from that because we also do that business of insuring vulnerable workers. The next one, Commissioner, I believe is the last one. Yeah, thank you. That's it. Thank you, Chair.
Thank you so much for the presentation. What we're going to do before allow members to ask questions for clarity. One, with regard to those, the bulk of the presentation deals with the issues that were raised with regard to administration of claims. We took a decision last time we made that we want to treat that one outside this legislation process, that we invite the fund to come and brief us on those issues. I know you have started doing that, but we will still continue with that because also we want to contact those that complained and hear their side and also request a proof on the allegation that they've made and then convene another meeting. We've also said that in our committee planning meeting last week, all committees of the NCOP, the strategic planning session, our committee decided that we still need to follow up on the issues that were raised by the stakeholders with regard to the administration of the claims. That's one part. So I would also request members that we don't deal with that area for now. We'll have an opportunity where we'll invite the fund to come and make presentation, but also take into account the issues that would have been raised by the stakeholders that we will contact. The second issue or the third issue or second issue, yeah, with regard to NETLAC. NETLAC is a result of a legislation of Parliament. But the point we're making is that it is a social dialogue platform. It makes it easier even for Parliament because we don't have to start afresh with the legislation. We focus on the amendments as presented by the department, which is also part of the discussion at NETLAC level. So we still respect, and actually NETLAC reports to this committee as well. So we're not dismissing the discussion that are taking place at the NETLAC level, but all that we're saying is that you can't say, here is an agreement from NETLAC, and we just implement it as committees. So that's the point I was trying to make, that we must still engage parties on their own without necessarily saying, here's a program, an enactment, so just implement it. The third issue, I want to send you back on this one, this presentation with regard to that part that deals with the proposed amendments by members. Want you to do it the same way that you dealt with the employment equity. Stakeholders that made presentation must be able to see their presentation and also your responses to the presentation. Now we are unable to determine which stakeholders you're responding to. unlike the presentation that was made by Ms. Mamashile, with regard to the employment equity, because there was a template there that Bosa said this, department agrees or disagree with this aspect, and so on and so on. As with regard to all the stakeholders that made submissions. So we want to suggest that you do the same, and that we get that report by Friday, so that when we deliberate next week, we have a clear report on what each of the stakeholders said, and also your responses to each of those. Because this one now, it's just kind of like an overall kind of a response to the submissions that were made, and making it difficult for members to exactly know what each of the stakeholders said and what is your response with regard to those stakeholders. But also the issue of the notices, notice 526 and 615. There's still another process. We remember last time we wanted to talk to the legal unit that is responsible for this bill. He has asked for more extension of time, and that he will be responding in writing to this notice 526, because we must still respond to COIDA because they raised this issue in the last meeting. So at this stage, then I will ask members to ask questions. Start with Honorable Dango, followed by Honorable Boshoff.
I am but concerned if they can clarify the point of the pre-funders. Now, the pre-funders, as I understand it, are debt collectors. And debt collectors, by and large, are people who put you in cement shoes and staple your knees together. They're not going to perform the kind of services required. Also, I asked the question of those pre-funders in another meeting, I think it was employment of labor, as to what their margin of profit was, and they refused to answer. Thank you very much.
Thank you. Honorable Boshoff.
Thank you very much, Chair. And thank you for the question that you asked with regard to COIDA giving us the same presentation as the EEA. And on that, if we could ask Mr. Mafata, if I pronounce that correctly, yes, to make contact with the stakeholder that spoke on the 341 days that it took for a claim to be finalized, so that we can, if this is a once-off, or are there more than one or two or three third-party administrators that have the same problem with regard to time in which the fund completes a claim. We need to lay this to rest now, because Mr. Mafata really stressed that it does not take 341 days. Thank you very much.
Thank you. Thank you very much, Honorable Boshoff. Honorable Maima.
Thank you, Chair. Just one clarifying question for myself from the department. One of the comments submitted on the bill is a prefunder called COIDA, and clearly one of the issues that they raise, given the amount of claims as a debt collector as raised by Honorable Dango, is that there are many claims that have not been settled, and the impact of the amendment to Section 734 through the insertion of those two sections will have an impact in terms of the existing claim. So now the proposals that they are making is that the bill be made to apply retrospectively, and just understanding I mean, from the presentation that we had, I think it was last year or 2 years back, on the conceptual understanding and framework within which the principles of retrospectivity applies. It's a bit tight. So now I want to get a sense from the presenters to whether this element of retrospectivity or the bill applying retrospectively to cover the claims, which is more than 1,000, if I'm not mistaken, or more than that. What is their view with regard to the suggestions that the bill must apply retrospectively to cover claims that are already submitted? Thank you.
Thank you very much, Honorable Mwima. Any responses, Commissioner and the team?
Thank you, Chair. Chair, I'll just go first and my colleagues will add. I'm sure Mr. Mkhalip would also want to say something. Chair, I think we take note of all the comments that have been made. We will certainly ready ourselves for that engagement on those administrative issues, and we'll make sure that we come ready and bring all the relevant information that is required. And I think it's in that engagement that Honorable Boshov's also comments around the statements by the pre-funders and so on. Those things would then be put to bed in those discussions. The question on Honorable that was raised by Honorable Dango around the pre-funders, rather the comment, right? So I think that's if the third parties are deeming themselves as debt collectors, which is even more concerning because then they play no role in administration of a COID claim, and they shouldn't be allowed to play such a role. Which is a bit more concerning. And I think it's why we're proposing that the minister be allowed to regulate the conduct of those that call themselves third parties, so that there is clear rules that everybody needs to comply with. Because as I said initially, the ultimate beneficiary of a COID legislation is an injured worker. An injured worker cannot be made to suffer while other people are benefiting because of the misfortune that the injured worker has that has befallen the injured worker. I think the issue of the retrospectivity, I'm sure my legal colleague would respond more, but in instances such as these, where we are making amendments to the bill, there obviously would be transitional arrangements in terms of clauses that are changing. And if there's any arrangements transitional that relates to any claims that would have been received prior to the enactment of the amendments, those would be covered then in the transitional arrangements that would have been made as part of the bill. And my understanding is that any bill applies prospectively, but those transitional arrangements would then take care of some of the issues that administrative that needs to be taken into account on clauses that are affecting workers. I'm not sure if my colleagues want to add, Chair. Thank you.
Okay. Any additions?
Thank you, Mr. Chair. I'm unable to raise the hand, so I hope you will pardon me for just responding without seeing my hand.
It's okay.
Yes, I agree with the Commissioner. In fact, legislation must apply prospectively and not retrospectively, unless it is actually the intention of the legislature that it must apply retrospectively. So I have looked at the transitional arrangement. We made only two provisions. One relates to domestic workers, domestic employees, that they would have 3 years to put in their claim with compensation fund, even though it is retrospectively to 1994. but those claims must come to us within 3 years of this bill becoming the law. And of course, the second one, it relates to the licenses. So all other claims, because by way of accident, and then by way of lodging that claim, there is legitimate expectation that you have now acquired a right, even though the claim is not yet adjudicated or liability accepted. Such claim must be dealt with as if this bill had not become law. In other words, they must be dealt with as if they must be dealt with under the provisions of the Principal Act before amendment. Maybe that's what we also need to put in the transitional arrangements. Thank you.
Thank you so much. The addition will be from the Department of Employment and Labor, which also includes its entity, the compensation fund. Anybody else other than the department and compensation fund or members of parliament? I won't allow anyone else, if you are not a member of parliament, you're not from the department of the commission fund to speak. I'll check with Millie from the department or from the commission fund, because I see the hand is up.
Good evening, Chairperson and honorable members. Just to add, I'm from the compensation fund, just to add to what the commissioner was saying. With regard to just one of the third parties that presented, just to give you an idea, I believe that we will trash this out in the session that we will have with you. We have received more than 550,000 invoices from the particular third party to the value of just over 1.9 billion rand. And we have authorized for payment more than 1.7 billion rand, of which more than 1.4 billion rand was within less than 40 working days. But I believe that when we have the session with you, we will be able to address this particular matters. Thank you.
Thank you so much. I was a bit worried. I thought you were one of the stakeholders. And I indicated at the start of the meeting that only the department, compensation fund, and members that are allowed to speak on the issue, because the stakeholders had their opportunity. We will follow up as a committee. The committee secretariat will be conducting the compensation fund, will be also conducting the stakeholders, or so-called third parties, or service providers, medical service providers, those who want to contribute or raise issues around these processes of medical claims. We will conduct them as Honorable Boshoff said, so that we deal with these issues once and for all. But I want to go back to the issue that is going to assist the committee, that we need a template that will indicate in terms of each section of the bill where stakeholders have made comments or proposals, and also the response of the compensation fund with regard to the proposed amendments or comments that have been made by the stakeholders. So that kind of a template, and the deadline will be Friday for us to receive such a template. Agreed, Mr. Matapo? Commissioner?
Agreed, Chair. Agreed, Chair. We'll submit it before Friday. Thank you, Chair.
Thank you so much. Committee Secretary, is there anything else?
Yes, Chair. We have 3 sets of minutes to be adopted, and we still have a quorum.
can we just deal with this process of legislation, and then when we deal with the annual report of the Department of Labor, we then deal with all the minutes that are outstanding.
Okay, Chair. All right.
Thank you so much. That then brings us to the end of the meeting. Next week, as I was indicating, we will first deal with the report from is it Mr. Mjengane?
Yes, Mr. Mjengane.
Yeah, around the issue of COIDA. Yeah, including the issue of the notices 526 and 615. The department has also responded to that issue in their presentation that it doesn't have an impact of the bill, but we would like also legal advice with regard to that issue. Yeah, and then we would then start with the deliberation on both the employment equity and also the COIDA amendment bill. And then the following week, we deal with the report. So that is going to be the process, honorable members. If there is nothing else, just give the opportunity for members want to make any comments before we close the meeting. And not. Let me take this opportunity then to thank the honorable members for their attendance and their participation in the meeting. Also thank the Department of Employment and Labor, Mr. Mkalepi, Mrs. Nzwaki, Mamash. I see in the list there, it's not complete. It's Mamashile. Mr. Voyon Matafa and Mr. Heri Mapolo Hela, if I'm pronouncing it correctly. Thank you so much. And also let's thank also the stakeholders that made submission last week. Some of them are here to hear the responses of the department on the submission that they've made. You are welcome to also attend the meeting next week to hear when members are deliberating on the two bills. Thank you so much. And also thank to the staff of the committee and also other staff members of Parliament. Thank you folks very much. The meeting is adjourned. And also thank to the Office of the State Law Advisor for also coming and attending the meeting. Thank you. Good night, everybody.
Thanks, Chair. Good night.
Good night.
Thank you, Chair.
Thank you, Chair.
Thank you so
Recording
much.
stopped.
Thank you, Chair.